Good morning, everyone. I'm Patty Engel. I'm pleased to be here today. I'm from Schott Felbeltz Engel. I have been representing families on school law matters for over 25 years. And I'd also like to introduce my colleague, Mary Gerbig.
Hi, everybody. I think I know many of you in the room, but not everyone, but it's a pleasure to see you. I am from the firm of Davis & Kielthau. I also have been representing in the area of school law for, I don't think I've quite hit 25 years, but I'm getting close. And, I'm delighted again to be here and be able to talk with all of you along with my colleague Patty. Patty actually, I had my first case in this area with Patty many years ago.
Oh, I didn't know that.
Yeah,
You'll have to tell me which
case
that was.
But we share, I think, some both some common views relative to the law and some perspectives then that are, I think, unique to each of our practices. But we're hoping to talk in a dialogue with you about a variety of areas that we think you as mediators really do need to, as I would say, keep your eye on the ball, not get distracted by, but at least have in your broader vision when you're in the mediation process. So with that, I'm going to turn it back over to Patty, and we'll be doing a little back and forth dialogue today.
And you gave them the outlines?
Yeah, my understanding is that everyone already has an outline along with their presentation today.
Great. And please don't be alarmed at the length of it. We are, it is it is not our intent to, tell you about all of that, but it'll serve as a good perspective. As Mary said, we like to have a dialogue. We like interchange, so please ask questions as we go along. Makes it more lively and interesting. We're here to help you and answer your questions. So that's what we'd like to do. So we are going to start with our longest topic of the morning for update, and it is the Andrew F. case, and the issue is FAPE. And for the new people, I'm sure you are so tired of hearing that about FAPE, but it is such a crucial part, and you're coming in at a really good time because after 35 years, we're getting new information, new from the Supreme Court, new guidance to help us determine, what is FAPE, what is a child entitled to receive when they have an IEP? What's the special education that they and related services that they are entitled to get in order to have a free, appropriate public education? And it's that word appropriate that makes it individualized for students and allows to provide for the unique needs of each child. But at the same time, the word appropriate is what gives Mary and I a lot of work in the business, because we are at odds as to what does appropriate mean. So by way of background, 35 years ago, the Supreme Court gave us the decision of Rowley, and that is what we've been using since then to gauge, is this student's IEP appropriate? So what did Rowley tell us? That the IEP should be providing benefit to the child. The IEP should be reasonably calculated to enable the child to achieve passing grades and advance from grade to grade. They described a twofold inquiry. Did the district comply with the procedural requirements of the statute? And was the IEP developed through those procedures to be reasonably calculated to enable the child to receive educational benefit? If the answer is yes to those two questions, then the district met their obligation for FAPE. But Rowley also used terms like, well, there's a basic floor of opportunity, and the district is not required to maximize benefits, and the student should have access to education sufficient to confer some educational benefit. So for 35 years, we've been trying to decide what is some educational benefit under that Rowley standard. And then this spring, we got Andrew F. from, again, a Supreme Court case that worked its way up. It came out of Colorado, and there was a due process hearing. And the parents, to give you a little bit of background, the parents filed a due process hearing against the school district because the parents felt that for their, I think it was a 5th grader, the IEP was stagnant and it seemed very similar year after year, and their child wasn't making progress, and in fact, he had a lot of behavior issues, and so they felt that they weren't even getting to the academic or educational portion of his program. It was all about behavior. And so the family ultimately decided to remove the child from the public school, placed their son Andrew in a private school placement, and what they saw was change for the better for their child. There was a behavior plan put in place. There was focus on the behaviors. They got those under control at the new school, and then were able to switch focus to academic progress. So when the parents saw the possibility for their child, they ended up filing a due process hearing complaint against the public school district, saying you denied FAPE. What you were providing was not a free, appropriate public education. We want you to reimburse us for our tuition. The administrative law judge, we talked about on Monday what that process is for a hearing, so they went through that hearing. Administrative law judge said no. Under the law in Colorado, all the district is required to do is to provide an education that's merely more than de minimis. That's what the district did. I think we can see some, there is at least merely more than de minimis progress. So this is not a denial of FAPE. Parents did not prevail. They lost. It was then appealed to the federal district court, where same result. It was then appealed by the family to the 10th Circuit Court of Appeals, and the same result, that under the law as the 10th Circuit interpreted Rowley, there was FAPE, there was educational benefits sufficient under Rowley. So the Supreme Court decided to take that case on to give us some new information to, I guess, to reanalyze, is this really all that you can expect from special education? And the decision from the Supreme Court did a thorough analysis of looking at Rowley and looking at how Andrew F. interpreted it, and determined, in fact, that Andrew F. did not receive a free, appropriate public education. FAPE is more than just that merely de minimis. That's really exciting information from my perspective, and there were some new phrases that I think, new language coming out of NJREF that we can look to. They saw the value of Rowley, and it's not as if they totally scrapped Rowley, but I think they added onto it. And most importantly, I would say the new court and the new standard for FAPE talks about progress that the IEP, again, is reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And that every child should have the chance to meet challenging objectives. The court also went on to say that it is markedly more than de minimis is what we're talking about. So new information, and I'll talk about my perspective of it later, but I wanted to give Mary a chance to weigh in on this.
I'll try to go to here. Okay. Well, first of all, what were y'all doing in 1982? What were you all doing in 1982? In 1982, I started teaching. Schools were, by and large, segregated for students with disabilities. It is true. Students with disabilities primarily were sitting out at schools that were either within the large urban areas or someplace else, okay, programmatically, and or if you were out in the rest of the state, our kids were sitting out in county schools, okay? So Rowley happens, and it happens in the context of a really segregated world for students with disabilities. Okay, we won't talk about the rest of it. You know, I was going to start, where were you in 1959? Okay, because if you really look at the trajectory here, it's really Brown versus Board of Education. That is the trajectory. And you have a trajectory that is both a legal framework as well as social, right? That's what happened here. 1959, 1965, then you have the Rehabilitation Act that comes on the scene in the 70s. Then you have IDEA and Rowley, which is a big deal, okay? But the law has not been static since 1982 to today. It's not static. And in fact, we have had big changes. They are dramatic changes under IDEA. And, you know, quite frankly, it's not like a silo. We haven't had the IDEA sitting all by itself. And one of my great frustrations when we sit in mediations is to think, okay, you know, do we see the forest for the trees? Or are we focused on one little branch at times, okay? The IDEA sits at 1982 as a very different law than it sits in 2017. And quite frankly, we have had dramatic changes. If you look at 1996, you know, you can't have a discussion about the facts of Andrew without looking at 1996 and saying, oh my God, there was like a seismic shift in the law. What happened? We went from a law that said, hey, we unilaterally, as school districts, let administrators place kids. Okay, placement was not a team decision. It was not, okay? We had a seismic shift in terms of IDEA in 1996. And by the way, what else came on the scene in the late 90s in the regulations that you had never had before in the law? BIPs. We talk about them all the time, behavior intervention plans, okay? You also have this really incredible mix of that social scene. And after 1982, if you look at what happens socially and educationally, we made light years of progress in the school districts in terms of, after Rowley, moving to tremendous programs where we actually are integrating students in educational programs at a rate we had never done before, and successfully integrating students. So I have to say, you know, you can't look at Rowley and look at the standard in Rowley and say that the standard in 1982, as applied in 1982, is the same as it looked in 1992, 10 years later, and 10 years later. So Rowley, that standard really evolved over time. You know, when you look at what that twofold test was, you really have to say, okay, look, you know, when you talk about whether a school district or a state is complying with the procedures set forth in the statute, well, the procedures changed, and they changed dramatically. And what they did is they bumped it up. They bumped it up dramatically. And whether those procedures and the calculation of an IEP was going to enable a child to receive benefits, well, over that 30-plus year period, it bumped up dramatically. And here's where you got to look. This is a keep your eye on the ball. The ESEA, the Elementary and Secondary Education Act, if you look at the progression of that from the 60s to today, you know, we forget that in the early 2000s, we said we're bumping up the accountability in public education. And that was true for students with disabilities too. It is a major factor. And when you put those two laws together and you harmonize what has to happen, we have been, since the early 2000s, saying, you know, hey, the majority of students, the vast majority of students, need to be held to an accountability standard, disabled or not disabled, that is the same. We have cells that we have to count in education that are very small in terms of the number of students that can be on some kind of alternative assessment. And I got to tell you, that overlay with the IDEA tells you that the accountability and where we have to be, that in and of itself tells you that we're way past a de minimis kind of standard, okay? You can't look at the IDEA and say it's a silo. It is not a silo. It is interacting with these other big laws and statutes, and it does change it changes how you look at the Rowley standard. Now, I am not going to jump onto every piece that we have in this outline, but I just want to say that if you look at the Seventh Circuit, one of the things that happened here is that we had over many years a split that developed in the various federal circuits. And that split in the circuits really, you know, we could see big differences between the Third Circuit and the Seventh Circuit, huge. And I would tell you others as well. My own view, the Seventh Circuit was faithful to that evolving picture under changes in the IDEA and how it interacted with other laws. I think it was faithful. I think that if you look at the cases over time, you can't look at these cases without how did the statutes change, the regulations change, and socially what was happening in the schools. and that if you look at the facts, F-A-C-T-S, the facts mattered. And in each one of these cases, I think you see a progression of the Seventh Circuit saying, here are the words, but here's where you have to get in terms of the factual analysis. And that over time, that factual analysis kept bumping us up. I think that when you look at the facts along with the analysis in the Seventh Circuit, I actually don't think that we are that much different than the words that actually have now been uttered in the Supreme Court in Andrew. And I also think that when you look at the language in terms of appropriate in light of a child's circumstances, those are the special words, you know, that come from the new Supreme Court case. I think you look at those words and you say, you know, I hate to say, those words can pull you both up and down. Because in light of a child's special circumstances can be, for example, a student's cognitive ability, all right? And you are going to look at, okay, what that student's potential is going to be, okay? Is the student who is, you know, a much lower cognitive level, are we going to have to make sure that that student is able to make enough progress to get to a 4-year school? And I think that the analysis here tells us, no, you're going to get to look at the specific facts and circumstances of each one of these cases, and you're going to be able to say, there are facts that tell us how much progress is enough progress. I still think that's the same as what the Seventh Circuit has already been doing. Patty, you want to keep going?
Well, do you want to talk about your practical implications that you had?
Well, okay. Let's go back to, I'm on page 3 of the outline. Okay. Do I think NREF has provided the opportunity to strengthen services for students with disabilities? Absolutely. I think it was there in the Seventh Circuit already. Do I think the case stretches students' academic potential, especially those students with more significant disabilities? Yeah, I do. I think that's already there, though, in some of these other statutes. I don't think you get to look at the IDEA alone. I think you have to look at the IDEA in light of the ESEA, now ESSA, ESSA. For everybody in the room, you know, it's the next version of No Child Left Behind, and it does produce a standard of accountability, and it does hold us to that standard for students with disabilities. You know, behavior intervention plans, they're here to stay. There was a point at which in 2004, prior to the last reauthorization, there was a lot of question about whether or not they were going to keep behavior intervention plans in IDEA. You know, there was a lot of comment across the country. That comment said, essentially, hey, why would you take these out? They actually work. They're an educational piece that works. And so why would we take them out? Now, behavior intervention plans, they are an educational concept first, and then they are given some meaning in the IDEA. As mediators, what you should know is that there are probably more circumstances where we probably should be looking at behavior intervention plans and maybe don't have them in place always. That proactive advice to everybody is, if you're in a facilitated IEP or if you're sitting in a mediation, and if the whole time you're talking about behavior and you haven't talked about the behavior intervention plan or whether or not they're making changes to that, there should be like huge alarms going off. Okay, we should be talking about behavior intervention plans.
I just want to comment on that. Yeah, I've had over the last few years several mediations that we resolved when we decided to do a behavior plan. Right, an FB, a functional behavior analysis, and then a plan. And me coming from a psychology background, background, special ed background, behavioral disabilities, like, why didn't we do this before? So I see them just as really a crucial part of that process.
Oh, absolutely. Now, let me also do the flip of this. Now, I'm saying to everybody, you should be talking about behavior intervention plans, and what comes before it is a functional behavior assessment. Is there any one absolute way that you have to do that? No, but if somebody doesn't, if you're all talking about functional behavior assessments and behavior intervention plans, and if somebody doesn't say the magic consent words, you should be talking about consent, okay? Because on that functional behavior assessment, we should be seeking consent if we are a school district. And that the gentle reminder is, how about consent? Yes, okay? And I'm talking written consent, okay, from the parent. I also want to just say, okay, Kay. Loaded? UK? No.
I was wondering if you think that this particular language in the Supreme Court is going to open it up to more use of expert testimony if it actually goes further, because it's so kind of similar to civil.
Oh, okay. Can I go first and then?
Please.
Then, there are very few cases where I think they are purely legal questions, or at least up to this point. I think we would agree. I think the fact-based questions, and then as the law is applied to it in any of the due process or any kind of appeal process, you know, again, the facts rule the day. The facts matter. And in terms of expert testimony, I think we've always had, you know, an expert testimony battle in these cases. I can't imagine a case that Patty and I would be in where we wouldn't at some level be
Right.
talking about experts. Patty, you want to go?
Right, I agree. First of all, Kay, good question. I hadn't thought about that. I think another point is, and you'll see later on in our presentation, there are not that many due process hearing cases in Wisconsin. But when we do have them, I think I've always had an expert. I think that's just the way it is. And as Mary points out, these are all so factually driven, right? That that's where the difference in all these cases, and again, that's that whole appropriate. That's why I keep going back to the word appropriate in FAPE.
Right, absolutely. Absolutely. Tom?
Is an FBA required before you can do a BIP? The answer to that is yes, and the parents don't consent. Can the IEP team develop its goals and objectives, strategies dealing with behaviors as a part of the goals and objectives if the parents don't consent to an FBA? If the FBA is a prerequisite to the BIP?
Well, I'm going to ask Patty to jump in on this too, but okay, so this whole, do you have to have an FBA that precedes the behavior intervention plan? Let me tell you where you see that language. You see that language in the regulations that govern us in terms of the alternative disciplinary rules. They sit under the 34 CFR section 300.530 if you feel like you can't sleep and you need to read. But that section is really the section that drives us in terms of, and it's like an after the fact kind of piece. It says, like, if these bad things happen in school and now these kids are subject to disciplinary processes, you got to look to see whether or not you did do a functional behavior assessment and a behavior intervention plan. It's sort of like way after the fact, okay? And then it changes how you process the discipline. But it causes, I think, people like me, and certainly people like Patty, to say that when you get to those annual IEP meetings, we should be reasonably predictive in terms of addressing behavior. And, you know, here's the question. Do you think
I
you
guess
have
I would
to
also
have-
say best practice.
And best practice.
Is to have an FBA, and when I'm involved in a case, I am asking for best practices.
So
That
Penny and Mary, is there a downside to performing the functional behavioral assessment?
No.
time, I think, is the only thing that generally we're doing this because there is a problem, and at that point, people want action, and they want action yesterday.
So, go ahead.
But it is worth it to step back and do the functional behavior analysis, because done correctly, you can learn so much, the team can learn so much information to guide us.
So at the district level, and to take it a step further, at the IEP team level, which includes the parents, I'm wondering why the functional behavioral assessment, but not even that, I understand that precedes the behavioral intervention plan. I'm wondering why the behavioral intervention plan has not become protocol, has not become a staple to that process.
Well, let me just say, I think what you're saying is, hey, do you always have to do a functional behavior assessment before you do a behavior intervention plan? And at least arguably, at some junctures, you might not have to do a functional behavior assessment before a behavior intervention plan. But then you got to ask the question, hey, wait a minute. Okay, do you have good information to base the behavior intervention plan on?
But what
Right?
I'm saying, what I'm proposing, Mary, is my question is, so whether you need it or not, why is it just not a given, again, staple part of that process?
Because every child does not require a behavior
Yeah.
intervention plan. If the student is eligible because of speech, and there are no behavior issues, concerns, problems that are impacting the ability for that child or other children to get an education, we don't talk about a behavior plan.
So my thought is, if it's never mentioned, it's not thought about in some instances. So again,
Should we be asking the question?
yes.
Should we be asking the question? And
Yes.
honestly,
And ruling it out.
Honestly, kind of a best practice piece. Many of the school districts, we do say in the schools, like, at least ask the question for that annual IEP. You know, have we taken a look at that record review, you know, and to look and see, like, what has happened behaviorally for kids? And sometimes these are system issues, you know, who's at the table. You know, I may or may not be
Right.
looking at the referrals.
But I would also
Annually.
say, I think the special factors page
Does.
is a good point for the IEP team, because the first question there is about what are the positive behavior supports. I mean, that's just begging for the word behavior intervention plan to be at least discussed.
And isn't
Yeah.
the reality, I mean, you've got, a lot of these cases, you've got, you know, many, many people on the IEP with many, many different specialties. And they are dealing with the child day in and day out. I mean, it would seem to me that it would only be logical and realistic that the IEP team, excluding the parents, have a sense of whether their behavior should with this child. And would be talking about that amongst themselves, if nothing else.
Right. And all I can say about that is when we're involved, it's often a topic. My personal belief is, I'm wondering if sometimes these teams have a lot, you know, those are thick documents to go through, and maybe it doesn't always come up as like it should.
Yeah.
Because of time,
Yeah.
yeah.
I would add to that, if you look at a typical IEP process and you look at that paperwork that really drives our process, okay, one thing that I've said to Patty is, why do I think that we're already at a higher standard in the state of Wisconsin? Well, because quite honestly, we got a whole heck of a lot more process in our daily IEP process, and we look different than other states. You know, and we can have people in a variety of other states that show us their forms. We look at our forms compared to their forms. We have more process here. And you can argue about whether or not all of that process really is required, not required, but over time, we've had a lot of process, and that process has become more prescriptive, and in many ways, actually, it's been a huge help to the schools to ensure that, you know, we're not just down at a floor. And I'm going to tell you, in public education, our IEP process is not, I think, generally at a floor. You can disagree about that one. But our process is not down at a floor. We have a lot of process that I would say kind of catches, you know, if people are falling and not, you know, putting in place these safeguards. Now, back to the, okay, what do you do at that annual meeting juncture related to functional behavior assessment and behavior intervention? And I guess if I was going to give mediators one kind of thought to put out when you're listening to these discussions about, you know, whether or not students are doing things, you know, with intent or not with intent, I would be asking the question, if you're having some kind of big behavior discussion, is it that a kid won't or can't? And is that disability preventing that student from being able to do what they need to do? Okay?
I see a big shift that happens between elementary and middle school in particular around this issue. In a lot of mediations when I've worked on this, it's like, okay, now in middle school, we're going to have all of these other expectations for this child. And the idea, you know, that he or she is just misbehaving because they're trying to avoid work and things like that. And I think that issue really comes down hard because the child's going through a lot of developmental changes at that point and so on, so we throw that into the mix as well. And that's a number of times when I really explored with the parties about a behavioral assessment, because otherwise it just gets lost in, well, he's just misbehaving, he doesn't want to, without addressing the factors that go into that, as well as it's somehow like between elementary and middle school, the disability changed and morphed into something else.
Okay, so I just want to spend a few more minutes giving my perspective on you know, what NJRF means for us. So you heard Mary's perspective, but I think it gives us a more robust standard, and I think it is pertinent that it was a unanimous decision by the court in, let's face it, a very divisive time. To get a you know, unanimous decision from you know, if you follow the Supreme Court at all, you see what the voting blocks are generally. I think that that's significant. And so I think that the Seventh Circuit's interpretation that Mary talked about over the years, I don't think it is sufficient today after NJRF. It talked about so how the Seventh Circuit interpreted FAPE under Rowley over time is that, again, an IEP reasonably calculated to enable a child to receive educational benefit that was likely to produce progress, not regression or trivial educational advancement. I mean, it's not by accident that they're using that same language of, okay, it can't be trivial. Well, that's exactly what the 10th Circuit just that's what NJRF talked about, just more than de minimis, more than trivial. So I think we are going to see change, and so this case is only less than 6 months old, this NJRF, and so there have been a few cases around the country from the other circuits, not Seventh Circuit, but there was a Ninth Circuit case, and their standard before NJRF was reasonably calculated to confer meaningful benefit. I would say meaningful benefit is even higher than what Seventh Circuit had, and yet when that Court of Appeals looked at the case, the Ninth Circuit decided NJRF is more robust than meaningful benefit, and so that was a recent case that said, okay, we have to step up our standard, and I think that's what's going to happen in the Seventh Circuit as well. I think NJRF gives us a new starting point. Rowley had talked about the floor of opportunity. This elevates us, right? Our starting point is what is possible. What can this child, in light of this child's circumstances, in light of the peers, what are challenging goals to see progress for this child? So when Mary talked about, the accountability standards, I think they do take on additional, that will be an important focus that we're going to look at now as we interpret NJRF. But I'm excited about it. And it'll be interesting to see where we go in the next few years. Hopefully not 35 years. We'll get it sooner than that.
Let me ask this question in light of the question that was asked earlier about expert testimony. In your opinion, do you believe that the majority of IEP teams in the public school systems, or any system for that matter, are equipped to be making the assessment as to what this, and I'll use the severely disabled student, what are the potential educational attainments? What are the realistic potential educational attainments? Can the IEP team actually function in a way to get at that, or is it going to require experts who have specialized in that particular severe disability?
So I guess my response would be, as we talked about on Monday, the IEP team is appointed based on, what are the needs of this child. So I would expect that there is going to be at least one special ed teacher with knowledge and expertise on, given the child's cognitive ability that we're working with. Is this, severely? Well, but I'm big, and I don't know how often it occurs in districts otherwise, but I'm big on asking team, let me back up. I only get involved when there's a problem. No one invites me to an IEP, for the fun of it. So there's a problem right away when I'm coming because the family does not feel that the IEP is meeting the child's needs. So often I am requesting that the team bring on a consultant. That, okay, this team, I admit this does seem to be a complicated case. You've been working with the child for X number of years. We're not meeting, we feel that we need more information. We need help. Do you have someone within the district that can provide that consulting? Sometimes we go outside the district. Sometimes there are DPI people that
And other experts that we use, educational experts, but I think one thing that I think Patty and I would both, and this is I think why we very respectfully disagree about whether or not we're already there at a higher standard, and I think we are. And I think if you look at the facts of the case, we were already there. But this is why. Because what we're going to say next is we're going to have a data-driven kind of discussion. And when you talk about experts, you're going to talk about a data-driven discussion. Sometimes those experts come from within school districts, sometimes they come from outside of school districts, but they are going to be talking about the data that we collect related to how students are functioning and how they are making or not making progress over time. That has an absolute direct relationship to all of the state assessments that are really the accountability that you see that was an outgrowth of No Child Left Behind. Okay. Okay.
So this is a candidate mediator question about how to get from here to there. And here it is. If we as a mediator sense that this issue hasn't been addressed, that there's something deficient about behavioral supports and whether or not there was a FBA in place, what mediator language should we be using to explore this in a neutral way? Is this a caucus issue, or how do you do this?
You want to go first, or do you want me to?
Sure. I have the utmost faith in the mediators, and I wouldn't presume to say what method. I've seen a variety used, and it seems to me that they really base it on the dynamics of the people. But at any rate, as you were forming that question, I was thinking, boy, I could see a mediator, acting innocent and just posing the question like, so I'm confused. Is there an FBA? Can you? How did the FBA go, or what happened? I could see that. I could absolutely see it being done in a caucus if you. But I personally appreciate when the mediators bring in make suggestions, raise our awareness. I don't know, Mary, how you feel about it, but
yeah. I mean, I think there are some wonderful ways to get at it. As you do all anyways. When you say, "Hey, seems like there's some missing information," or "There's a gap in information here. We're having this discussion, but do we have some information about?" And one of my questions is, do you just focus on the behavioral? And I would certainly say to you, don't do that. Also, focus on the academic. And you get so much information that is not only academic but also behavioral by just taking a look at how kids are doing on those state assessments or district assessments. Sometimes they're not valid, but they can tell you a lot. Or saying, okay, how does a kid do on the state assessment or district assessment, or how do they do on if they do some other kind of alternate assessment on other assignments, and under what circumstances? Tells you a lot. If you have some kind of data that tells you about, in our world, we would be saying, what's that, pre-teaching data, and what's that post-teaching data look like? And again, those are the pieces that you as mediators need to say, hey, there's a missing puzzle piece here. There's some missing information. Do we have it? If we don't have it, let's go get it.
This is just a short, practical comment. Sometimes in caucus, if something like that does come up, I will go say, maybe you would like to check with your attorney on whether or not you have sufficient information or something like that. That's a good phrase. Maybe you want to check with your attorney.
I'm all for it. Give me a call. No.
I think, in addressing your question, I think first thing is a lot of times that kind of Columbo question about, I'm interested to know, what data you have, but to me, a lot of times it's the next question that is, to me, I found really important, and that is, how do you know that? Because everyone in that room will have an opinion about that kid that they've developed sometimes over years. And then have them actually explain how they know that. And some will use, well, I have this data, I chart this all the time and so on, and others have nothing. And then to really push to how are you going to get that data, because that's what you're going to need.
Okay, we have two more questions, Melody and then Sue.
Okay, I'm kind of loud anyway, so I'm gonna try to not overshoot here. I've been wondering how you think the INDER-F decision is going to affect the twice exceptional population that are both gifted intellectually in some areas and have learning disabilities as well, when you consider in light of their capacities, what that means.
Right. Again, for me, I am excited about that potential now and the idea of the challenging. This child is entitled to challenging goals and objectives. That's clear language. I like it, and I think it's a very good question, because I think we would need to step up our game for those children.
I'm gonna go there and just say, hey, better read the statute and read the regulations, because guess what, kids? There's language that already addresses it. And you know what? Those changes in the DPI forms that go both to, you know, the academic and behavioral needs, they go right to this question. And don't forget the words least restrictive environment. You can't, and the IDEA is not a silo law. There are some other laws that are at play here. And if you look at the broader picture under, you know, what the Office for Civil Rights has really been looking at for a long time, is whether or not, you know, there are whole classes of students that are being discriminated on the basis of their disability, okay? That goes to the twice exceptional kid. Do we have rules in place for certain programs that by their very nature start to exclude students? And we see big guidance that has hit us on, you know, Title IX related to kids with disabilities and athletics, but it goes much farther. If you really read that language is already there. It doesn't just sit over in the IDEA. It's the civil rights piece.
I actually have a comment to Rich. So, like in any conflict around data, first, what is the data? And sometimes, like the school has collected data, but the parents never saw the data. Or they didn't have time, they saw it right now, they didn't have time to process and check it with their own data. Because the parents usually also have data, but they may not have shared it with the school. So just getting the data out on the table, and then how did you arrive at that data, and what does it mean? So what does it mean that happens always during specials? What does that mean that it happens when there is less oversight, like at lunch, at recess, at transition times? So then being able to look at the data, but what is the data, what does the data mean?
You're reminding me of photographs that get brought into mediation, and the great thing to do is ask if the other party, have you seen this?
Exactly.
Mediators, don't be afraid to say to school districts, don't be afraid to show parents the data. Okay, sometimes schools get like, I don't really understand it myself, but they get a little shy about wanting to share the data with parents, and it's okay. It is okay. We have some questions that surround, you know, whether or not information related to some tests is copywritten, but there are easy ways to get past those issues. So I'm just going to say we should encourage the schools not to be afraid to share that data, okay?
I'm just going to comment that
Yeah.
That's great, but I've been in cases when you're not involved,
I know.
where I think districts don't give that information because they don't know what the family's going to do with it or how they're going to use it. And so I think in their mind, less is better. That,
Daryl has a question or comment.
You know, actually, it's a comment for Ruchi. I think that there's a timing to questions that are asked in a mediation. And sometimes, for me as a mediator, that timing can either take me out of my neutral zone or keep me in my neutral zone from the perspective of the parties. With me? So what I routinely do is I just sort of say, point of clarification for me. And I say that to the group. It keeps me in my neutral zone, and then it allows me to ask that question, whatever that question is, and just move from there.
okay, well, we wanted to focus on NJRF, but we need to move on. So we're going to do that. Mary.
Okay, I'm going to do the speed tour of OCR and some of the dear colleague letters that have come from OSEP.
Page 5.
Oh, I'm sorry. And really, again, our thought, Patty and I, was to at least get in front of you various areas where, you know, like I am big on saying to everybody, you're not looking at just one law, and there can be more pieces to the puzzle that can be going on in these IDEA disputes. And, you know, things to keep your eye on. We do have a variety of dear colleague letters that get issued, you know, annually, and you know, just basic areas that you should be aware of. You know, the dear colleague letter that talks about, you know, when you have personally identifiable information or records of students that are going to be destroyed, just know that we have a variety of state and federal laws that govern pupil records. And that there is a special provision, you know, section under IDEA also that speaks to records. Just be aware of it. Really, you know, you can't sit in these IEP meetings without understanding that if you've never done this, that you might get to this point where they're doing the post-secondary goals, but that is an electronic system, you know, that is live with the state. And my suggestion to all of you is that it could be a very frustrating process if you haven't done at least some discussion before you get into the electronic part of it, okay? And so my answer on that one is have a prep discussion before you engage in that. The next one is just a dear colleague letter that tells us that the state educational agency must ensure that records under Part B are retained and what that retention period is. I raise this because you can have some very funky discussions about records in these mediations. And there are a lot of rules that relate to it. And it would be a place where I might say to everybody, if you think that it's getting pretty funky, that would be a place that I would at least take a time out and get other information to sort out the record issues. There are other rights related to the records under FERPA in terms of other hearing opportunities that parents can have. And, you know, I would just very respectfully say it can get a little funky in some of those discussions. And so before you get into a dispute, you know, I'd take a time out and make sure you have accurate information. The dear colleague letter from January, the next one, guidance that states once a child turns 16, the student's IEP must include appropriate measurable post-secondary goals. Please understand that in the state of Wisconsin, though, we're back at age 14. Our law is just a little bit different. We're a little bit earlier on that, you know, talking about getting into transition. And the next one is just simply that you can file a due process complaint against a state educational agency. I don't know if there's a DPI person here who would like to comment on that, but my experience in terms of watching these cases forever is, you know where you see that? Hawaii. There's a lot that you see in terms of the state, and it has to do with how their system is set up, the educational system for special education services. Probably bigger news is that under the Office for Civil Rights, as many of you are aware, we had a change in administration this past year, and we have a new Secretary of Education. And what you should know is that they have really changed the landscape in terms of the Title IX guidance. And one thing that I think Patty and I have both seen in our practices is that you can have a lot of these issues that are kind of happening at the same time, and they can have an IDEA overlay. All right, so you can have kids where they would be having gender issues, race issues, disability issues, bullying issues, okay, where they can be coming under that jurisdiction of the Office for Civil Rights, but it can also be coming under that jurisdiction of IDEA. And so I would just say to you that one doesn't come without the other frequently. And so you should be sensitive to the fact that we could have more than one kind of process or a set of laws that are governing it. Curiously, even though the Office for Civil Rights has said that they won't look at some types of complaints, they have identified 4 areas where they are going to continue to take cases, and you can take a peek at that on page 6. I just want to note that if you, again, look at the facts of some of those cases, even though OCR says they're not going to take cases that are just bathroom cases or locker room cases, if you look at the kind of cases they are going to take, which really get to the same facts, I would at least argue that they're probably going to be making some of the same decisions. It's hard to know exactly where they're going to go with this. I would tell you that I think that the gender issues and disability issues, though, we see a high correlation. If you look at the eligibility category of other health impaired, there's such a high correlation between the mental health kinds of issues and gender issues. It's very frequent that you will also see that disability overlay. And so I'm just going to say to you that the potential for these retaliation cases extremely high. I'm going to do a really quick journey over to page 11, and I would just want to point out one case that has been running up through the 7th Circuit and is still in process. And you've probably seen this case within a variety of news stories, but it's the Whitaker versus Kenosha School District case. And it tells you that the 7th Circuit is at a different place than the Office for Civil Rights, at least right now, on these gender issues. And it also pretty quickly, last fall, in right about this time, they looked at this case and they said, look, we think this is just plain old sex stereotyping. And I would tell you, if you look at the facts of this case, it's very similar to what I just said in terms of a student also having a medical issue that is a part of the overlay here. Back to the end, is there expert testimony in this case? You betcha there is. This case is proceeding forward, but interestingly, the 7th Circuit has said it's a pretty strong theme of sex stereotyping and this medical issue that's also a part of it. They have also said, at least in terms of the preliminary pieces of this case, they've said that they do think that it could, in fact, be that simply transgender on its own could be a protected category. That's at odds with some of the other decisions that we see out there. So it'll be an interesting case to continue to watch. The Seventh Circuit has been pretty, I mean, I would tell you that the Seventh Circuit has been pretty faithful on the IDEA issues in terms of the law. I also think the Seventh Circuit has been pretty faithful in terms of the previous case law precedent in this area. And so it'll be interesting to see, you know, where it shakes out if it is a case that will go to the Supreme Court at some point in time. There's not a strong record. I'm just going to say, from a legal perspective, the record in this case, if I was looking at this case a year ago, I'd be uncomfortable with the record that developed. And when the Seventh Circuit had the oral argument in March, to read the oral argument is a bit painful as a school district. It's a bit painful. So I predict that Whitaker is going to do okay in this case, and then we'll be talking about it. So I'm going to shift back over to Patty now.
I'm just going to continue with the broad overview Mary started. I am on page 6 with the Wisconsin due process decision. So for last year, there was one due process decision. There were more due process cases filed, but those were resolved and did not go all the way to decision, and or maybe they were withdrawn. But at any rate, there's one decision listed, and this was a theme that we see, and you know, important theme for parents. On Monday, we had talked about the rights of parents. Opportunity to participate in an IEP meeting was the issue in this case. Under due process, if you recall, we're looking at, the administrative law judge is going to be making a determination, was there a denial of FAPE? So in this case, procedural violation, the district did not give prior written notice, and the parents did not have the opportunity to participate in an IEP meeting, but the determination was it did not rise to the level of a denial of a FAPE. So that's important, how these due process decisions work. As opposed to the cases below are the IDEA, the IDEA complaints that are filed with DPI. And Christina Spector mentioned that she is one of the investigators. So that's these cases that we're covering below. And if you recall from Tuesday, she mentioned that there is not that determination of, well, does this rise to the level of a denial of FAPE? These are straight, was there a violation? If so, corrective action needs to be taken. And again, I think that there are some areas that are illustrative for mediators as to what are the issues that are being are concerns for families, what's coming before DPI. So in these first category are, again, the parental right to participate. In the first case, it was about, if you recall, we talked about the parent has the right to a meaningful opportunity to participate in the IEP meeting. And in this case, the district was found to have met their responsibility because they had provided multiple ways in which they tried to have the parent attend the IEP meeting. In some of the other cases here, again, in the next case, the parent has the opportunity to participate in the decision, the placement decision. And it was determined, yes, the parent did get notice and was able to participate in the decision. The fourth case on that page, this is one of those situations of joint custody. Both parents are entitled to get the invitation and attend. And in this case, the one of the parents did not get the notice, so it was a denial of an opportunity to participate, and DPI told the district to make sure your records are up to date so that going forward, both parents will be able to participate. The next page, these cases are all about IEP, what needs to go in the plan, what needs to, how do they need to implement. So that second case, it was all about DPI found that the school failed to consistently implement a portion of the IEP. It wasn't implemented as written. That was a violation. And many of these cases, when there's a violation, they're talking about, well, what kind of compensatory education services should be provided to the child to make up for what they missed out on. Same thing with the next one, number 3. It was found the district failed to provide speech services. So comp ed was awarded. Because it's all about what's written in the IEP. We kind of talk about it as a contract of services, and then the district needs to ensure that that the staff understand their obligations and duties, and that someone is actually implementing as the IEP is written. Okay, thank you. On that 6th one that's identified on that page, this was a situation where the district failed to evaluate in all areas of concern. And we talked about that. Part of that child find obligation, this school evaluated for reading, but parent had mentioned math. You could see from the records there was also a math concern, and DPI found that the district failed to properly evaluate by not doing the math as well. The next section on the independent educational evaluations, again, if you recall, that's another one of those protections, safeguards that parents have, right to seek an independent educational evaluation if the family disagrees with an evaluation conducted by the district. In this first one, it was the issue was, so once the evaluation occurred, well, what do we do about it? There was a reminder that the team must meet and consider the results of the IEE. District does not need to adopt, but they do need to consider what's this new information telling us. The other IEE case listed, there was an issue regarding, well, how many IEEs are allowed after an evaluation. Well, it's one for each assessment performed. So if there's both math and reading, then you could have 2, one for each. School district was taking a narrow interpretation, and so that was corrected by DPI. The other area is child find. Important area because it's in my mind, it's the gateway. It's, does this child does this child have issues that require us to evaluate to determine, is this child eligible for an IEP? Does this child require special education services? So in a couple of these cases, it was found that the district wasn't quick enough to, eventually they conducted an evaluation. They made a referral for special ed, but the determination was made, given the facts, given the difficulties this child was having, that evaluation should have occurred much quicker. So that was important. Mary, you were going to talk about the seclusion restraint and then flow. Yeah.
Okay, this is like the speed round. Speed round. Okay, go to page 9 of 13. What do you need to know? It's in bold, and I underlined it. Okay, when do you get to use seclusion and restraint? And keep in mind, seclusion and restraint, there is a big national view and guidance that has been put out. Guess what? We have 2 statutes in our law, not just 1, 2. One sits under Chapter 118. That's the big one. Then there's a little one. It sits over under Chapter 115. But what do you need to know? Use of seclusion and physical restraint is only permitted when a student's behavior presents a clear, present, and imminent risk to the physical safety of the student or others, and it is the least restrictive intervention feasible. And it can only be used for as long as that behavior really presents a clear, present, and imminent risk. And so if somebody tells you, yeah, we secluded for 2 hours, I'd be questioning that, okay? Property damage. Kids can do some things that really not okay. If a kid is gonna take a bunch of papers and they go whoosh, property damage, irritating, okay? Did it present a risk that meets that standard? If kid is massively escalated and they pick up a piece of equipment like this and they're about to pitch it at other kids and staff, can you intervene? You bet, okay? But if this goes down and they wreck the machine, okay, and the kid does it away from somebody else and it's not going to hurt somebody, property damage alone is not going to allow you to use seclusion and restraint. Just know lots of reporting requirements related to that under the statute, and you cannot talk about behavior intervention plans these days without also talking about seclusion and restraint. If you reasonably foresee that you are going to have seclusion and restraint being used, it actually has to be put in the IEP. And you cannot just use the words nonviolent crisis intervention. School district folks don't like to get into a conversation that makes them or parents feel uncomfortable, and they sometimes don't want to say those words. But the little statute that sits over in Chapter 115 says you got to actually use the words seclusion or physical restraint if you reasonably foresee that you're going to use that. You can't just use nonviolent crisis intervention, okay? And those are the words that you actually write into the IEP. Cops, we got a lot of school resource officers, but there's big guidance out there related to school resource officers and law enforcement. And I'm just going to say, it does come up a lot in mediation. And a lot of parents are really uncomfortable about, that interaction with their children and law enforcement in the schools. And so I wouldn't shy away from that, but I also wouldn't get into a tug of war over it. If law enforcement is being used the same for the student with this disability as all other students, you don't have to put those words into a behavior intervention plan. Like sometimes we all want to say, here's the progression. If we're really involving law enforcement in a way that is different, okay, for that student with a disability, then I would tell you I think we should identify that in a behavior intervention plan. And I can at least say to you that appears to be the view as well for many of the advocates over at Disability Rights.
Right, but I think it's important, what is the purpose of having those resource officers in
Absolutely.
the building? And it is
Absolutely.
not to be the disciplinarian. You know, they're there.
Right.
Well, first of all, there should be a specific written understanding of why they're there. But generally, we're talking about for illegal activity, not for the general disciplinarian issues, which is the district's responsibility. Now, there can be exceptions. I'm sure that's what
Yeah.
you were about to say.
But yeah, can
I
I
heard
just
the
say?
intake of breath. I
Yeah.
knew I was getting
On the speed
pushback.
round, let me give the disclaimers though. Again, you know, if you'll read all of this, I mean, we have to be clear with everybody in the schools that the educational purpose has to be satisfied first, and then, you know, then interface with law enforcement. Law enforcement is not a replacement for the educational service, period.
One comment, and then we're gonna have to wrap up.
Okay.
Brief comment, that is the SRO is responsible and supervised by the chief of police, not by the school. district.
Correct.
So they're responsible for the community, for safety of the community, and they don't report to the principal or, they're supervised by the police department.
Yeah, I mean, it's safe to say and fair to say, when Patty talked about agreements between, interagency agreements between schools and law enforcement, you bet, we're doing that kind of work all the time. And there are sometimes blurred lines. And I think we have to work hard to make sure that, you know, we have that separation between law enforcement and that educational service. I want to make sure that we get to this last section
Right.
very quickly because it was a request by our dear friend Jane Burns. And so, Patty, you want to jump onto that?
Well, yes, the last issue, it's on page 12. It's about a new executive order that was issued by President Trump back in February, and it is to eliminate unnecessary regulations. Not just in the educational realm, but across the board in all agencies. So all federal agencies need to identify regulations to be repealed, replaced, or modified. And the basis for that would be maybe the costs exceed the benefit in that agency's mind, or maybe the regulation is outdated, unnecessary, ineffective. So what happened is that there are regulatory reform task forces that have been appointed, and they need to, in the education department, they put out a list of what regulations they want to repeal, replace, and there are 150 of them. We have just completed a public comment time frame. There were 15,000 comments made on what the public wants to see, and different organizations like the National Association of Directors of Special Education, you know, so various groups are weighing in also. The concern is what is what regulations are going to be on the chopping block, and what's the impact of that, and also the concern about how this process is normally done. Like, how do you get a regulation, the legislative work that goes into it, and the Office of Management and Budget gets involved. None of that is involved here. What's happening is this is an opportunity to pick the regulation you don't like and propose it for the chopping block. There will be more to come by the end of the year, an update on, okay, what's going to happen, what are the proposals. The good news about all this is that there is back in 1983, there was the precursor to the IDEA, had an amendment that said you cannot procedurally or substantively lessen the protections provided for children with disabilities by amending regulations unless it is clear and unequivocal intent of Congress. So any regulation in effect in 1983 is safe in that regard, including core parts of Part B like FAPE and LRE and IEE and parental consent for initial special ed. Part C, which is birth to 3, that was not in existence in 1983, and so that's at risk. This is very interesting, disconcerting, and we'll see where it goes.
All right.
Okay.
Thank you.